A supplier contracts with Orion Textiles Limited and later discovers that the company has insufficient assets to pay a valid debt. The supplier seeks payment directly from the majority shareholder, arguing that the shareholder controls most company decisions. Under general company law principles, which argument is most likely to protect the shareholder from personal liability? A. Majority control automatically transfers company debts to the controller. B. Shareholders are liable whenever they influence commercial decisions. C. The company is a separate legal person from its shareholders. D. A shareholder becomes liable once company assets are insufficient. The correct answer is C. The company is a separate legal person from its shareholders. Let us examine the legal principle involved. Once a company is incorporated, it becomes a legal person separate from its shareholders. Therefore, the company is generally responsible for its own debts, even when one shareholder controls most of its decisions. Majority control alone does not transfer the company's liabilities to the controlling shareholder, so option A is incorrect. Similarly, influencing commercial decisions does not automatically create personal liability, making option B incorrect. Option D is also incorrect because insufficient company assets do not, by themselves, remove the protection of separate legal personality. Personal liability may arise in exceptional circumstances, such as fraud or a valid personal guarantee, but those circumstances do not apply here. Question 2. Which statement best describes the doctrine of separate legal personality? A. A registered company has legal rights and obligations distinct from its members. B. A company acts only as a collective name for its current shareholders. C. A company's property is jointly owned by directors and shareholders. D. A company loses legal identity whenever its ownership structure changes. The correct answer is A. A registered company has legal rights and obligations distinct from its members. Here is why this answer fits. Separate legal personality means that a registered company exists as a legal person distinct from its shareholders and directors. Consequently, the company can own property, enter contracts, sue, be sued, and incur obligations in its own name. Option B is incorrect because the company is more than a collective name for its shareholders. Option C is also incorrect because company property belongs to the company itself, not jointly to its directors and shareholders. Option D is incorrect because changes in ownership do not normally terminate the company's legal identity. Question 3. Before Delta Robotics Limited is incorporated, its promoter signs a supply agreement for and on behalf of Delta Robotics Limited. After incorporation, the company uses the supplier's materials but later denies liability. Which legal issue is most central? A. Whether the supplier had voting rights in the company. B. Whether the promoter disclosed the proposed business name. C. Whether the company issued shares after incorporation. D. Whether the pre-incorporation contract was validly adopted or replaced. The correct answer is D. Whether the pre-incorporation contract was validly adopted or replaced. Let us walk through the reasoning. A company generally cannot be bound by a contract made before it legally exists. Therefore, the central issue is whether a valid post-incorporation arrangement adopted, confirmed, or replaced the original agreement. The company's use of the materials may be relevant when determining whether a new contractual obligation arose after incorporation. Option A is incorrect because the supplier's voting rights have no bearing on contractual liability. Option B is incorrect because merely disclosing the proposed company name does not bind a company that did not yet exist. Option C is also incorrect because issuing shares does not determine whether the supply agreement became enforceable against the company. Question 4. A parent company forms a subsidiary with minimal assets, transfers risky activities to it, and presents the subsidiary as independent while directing every operational decision. Injured claimants argue that the corporate structure is being misused. Which remedy are they most likely seeking? A. Conversion of ordinary shares into preference shares. B. Piercing or lifting the corporate veil. C. Reduction of the company's issued capital. D. Appointment of the subsidiary as a proxy. The correct answer is B. Piercing or lifting the corporate veil. Now let us clarify the legal reasoning. Piercing or lifting the corporate veil allows a court to look beyond the company's separate legal identity in exceptional circumstances. This remedy may be considered when a corporate structure is used to conceal wrongdoing, evade legal obligations, or facilitate abuse. Option A is incorrect because changing ordinary shares into preference shares concerns shareholder rights rather than misuse of corporate personality. Option C is incorrect because reducing issued capital does not attempt to shield wrongdoing through a subsidiary. Option D is also incorrect because appointing a proxy relates to representation or voting and does not expose the controlling company to liability. Question 5. Which principle most accurately explains limited liability in a company limited by shares? A. Directors cannot incur liability while acting for the company. B. Creditors may recover unpaid debts from all employees. C. Members' exposure is generally limited to unpaid amounts on shares. D. Companies cannot be sued once their shares are fully paid. The correct answer is C. Members. Exposure is generally limited to unpaid amounts on shares. Let us understand why this is correct. In a company limited by shares, a shareholder's financial liability is generally restricted to any amount that remains unpaid on the shares held. Therefore, when the shares are fully paid, the shareholder normally has no further obligation to contribute toward the company's debts. Option A is incorrect because directors may still incur personal liability for matters such as breaches of duty, fraud, or personal guarantees. Option B is incorrect because employees do not become responsible for company debts merely because they work for the company. Option D is also incorrect because a company remains capable of being sued regardless of whether its shares are fully paid. Question 6. Evaluate each statement as true or false. A company may own property in its own name after incorporation. The correct answer is true. A shareholder automatically owns the company's assets in proportion to shareholding. The correct answer is false. A company's legal personality normally continues despite changes in membership. The correct answer is true. Limited liability prevents a company itself from being liable for its debts. The correct answer is false. Now let us examine each statement carefully. After incorporation, a company becomes a separate legal person and may own property in its own name, so the first statement is true. However, shareholders own shares in the company rather than direct portions of the company's assets, making the second statement false. The company also continues to exist despite changes in shareholders or members because it has perpetual succession, so the third statement is true. Finally, limited liability protects shareholders from personal responsibility beyond their agreed contribution, but the company remains fully liable for its own debts, making the fourth statement false. Question 7. A finance director secretly owns a consulting firm and persuades the company to award that firm a lucrative contract without disclosure. The contract price is commercially reasonable, but the director profits personally. Which duty is most directly implicated? A. The duty to avoid conflicts of interest. B. The duty to maintain share capital. C. The duty to issue annual dividends. D. The duty to register every contract. The correct answer is A. The duty to avoid conflicts of interest. Let us examine the director's obligation. A director must avoid situations in which personal interests conflict or may conflict with duties owed to the company. Here, the finance director had a personal financial interest in the consulting firm and failed to disclose it before influencing the contract award. The fact that the price was commercially reasonable does not remove the conflict. Option B is incorrect because maintaining share capital concerns the protection of company capital rather than undisclosed personal interests. Option C is incorrect because directors do not have a general duty to issue dividends every year. Option D is also incorrect because the central issue is the director's undisclosed interest, not whether every contract was registered. Question 8. Which document or internal rule set most commonly regulates the relationship between a company, its members, and its internal management structure? A. The external sales contract. B. The annual marketing plan. C. The company's constitution or articles. D, the auditor's engagement letter. The correct answer is C, the company's constitution or articles. Now let us look at the governing framework. A company's constitution or articles establish the rules governing its internal affairs. These rules commonly define member rights, director powers, voting procedures, meetings, and other corporate decision-making processes. Option A is incorrect because an external sales contract governs a specific commercial transaction rather than the company's internal structure. Option B is incorrect because a marketing plan outlines promotional objectives and strategies without regulating legal relationships within the company. Option D is also incorrect because an auditor's engagement letter defines the scope and terms of an audit rather than the company's internal governance rules. Question 9. A purchasing manager regularly orders equipment for a company. The board privately limits the manager's authority but does not inform suppliers. A supplier contracts in good faith after similar past transactions. Which doctrine is most relevant? A, capital maintenance. B, apparent or ostensible authority. C, minority oppression. D, compulsory liquidation. The correct answer is B, apparent or ostensible authority. Let us connect the facts to the governing doctrine. Apparent or ostensible authority may arise when a company's conduct reasonably leads a third party to believe that an agent has authority to act on its behalf. Here, the purchasing manager had regularly placed similar orders, and the supplier was unaware of the board's private restriction. Therefore, the company may still be bound because the supplier relied in good faith on the authority the company appeared to grant. Option A is incorrect because capital maintenance concerns the preservation and lawful distribution of company capital. Option C is incorrect because minority oppression concerns unfair treatment of minority shareholders. Option D is also incorrect because compulsory liquidation concerns the court-ordered winding up of a company rather than an agent's authority to make contracts. Question 10. Which distinction between shares and debentures is generally correct? A, shares represent ownership interests, while debentures represent debt claims. B, shares are always secured, while debentures are always unsecured. C, shares must pay fixed interest, while debentures receive dividends. D, shares mature on a fixed date, while debentures continue indefinitely. The correct answer is A, shares represent ownership interests, while debentures represent debt claims. Let us distinguish the two forms of corporate finance. Shares generally give their holders membership and ownership interests in a company. Debentures, however, normally create a creditor relationship because they represent money borrowed by the company. Option B is incorrect because shares are not secured debt instruments, and debentures may be either secured or unsecured. Option C is incorrect because shareholders may receive dividends, while debenture holders usually receive interest. Option D is also incorrect because debentures commonly have repayment terms or maturity dates, whereas shares generally remain in existence until they are transferred, redeemed, or canceled. Question 11. The directors of Nova Foods Limited declare a dividend after a profitable sales quarter, but accumulated losses mean distributable profits are unavailable. Which principle is most likely breached? A, separate legal personality. B, preemption of existing members. C, capital maintenance. D, apparent authority. The correct answer is C, capital maintenance. Let us examine the financial protection involved. The capital maintenance principle restricts a company from returning capital to shareholders, except through lawful procedures. Dividends must generally be paid from profits legally available for distribution, not merely from strong sales during one quarter. Because accumulated losses have eliminated distributable profits, declaring the dividend may unlawfully reduce funds that should remain available to protect creditors. Option A is incorrect because separate legal personality concerns the company's distinct legal identity. Option B is incorrect because preemption protects existing members when new shares are issued. Option D is also incorrect because apparent authority concerns whether an agent appears authorized to bind the company. Question 12. Minority shareholders discover that directors cause the company to sell valuable assets to an entity they control at an undervalue. The wrong is primarily suffered by the company, but the board refuses to sue. Which action is most appropriate? A. A personal claim for unpaid dividends. B. A petition to alter the company name. C. A request to remove the auditor only. D. A derivative action on behalf of the company. The correct answer is D. A derivative action on behalf of the company. Now, let us identify the proper legal remedy. A derivative action allows a shareholder to pursue a claim in the company's name when the company itself has suffered the wrong and those controlling it refuse to take action. Here, the directors cause the company to transfer valuable assets at an undervalue to an entity they control, so the loss belongs primarily to the company. Option A is incorrect because an unpaid dividend claim concerns a personal shareholder right rather than recovery for corporate loss. Option B is incorrect because changing the company's name does not address the improper asset sale. Option C is also incorrect because removing the auditor would not recover the company's loss or hold the directors accountable for the transaction. Question 13. What is the main function of a special resolution in company law? A. To approve routine decisions made by junior employees. B. To authorize major corporate changes requiring enhanced approval. C. To validate informal discussions held outside company meetings. D. To transfer all director powers to external creditors. The correct answer is B. To authorize major corporate changes requiring enhanced approval. Let us examine why a higher approval threshold is required. A special resolution is used for significant corporate decisions that require stronger member approval than ordinary business matters. Common examples include amending the company's constitution, changing its capital structure, or approving certain winding-up decisions. Option A is incorrect because routine employee decisions do not normally require shareholder approval through a special resolution. Option C is incorrect because informal discussions do not automatically become legally valid merely through this procedure. Option D is also incorrect because a special resolution does not generally transfer all director powers to external creditors. Question 14. Evaluate each statement as true or false. Directors owe fiduciary duties primarily to individual shareholders in every decision. The correct answer is false. A director may breach duty by taking a corporate opportunity without proper consent. The correct answer is true. Proper disclosure can be relevant when assessing conflicts of interest. The correct answer is true. Good faith alone always cures a breach of directors' duties. The correct answer is false. Let us clarify each director's obligation. Directors generally owe their fiduciary duties to the company as a separate legal entity rather than to each individual shareholder, so the first statement is false. A director who diverts a business opportunity belonging to the company for personal benefit without authorization may breach duty, making the second statement true. Proper disclosure is important because it allows a conflict to be assessed and, where permitted, validly approved, so the third statement is true. However, acting in good faith does not automatically excuse negligence, an undisclosed conflict, or another breach of duty, making the fourth statement false. Question 15. A controlling shareholder repeatedly uses voting power to approve excessive management fees to entities it owns, leaving the minority with no practical benefit from the company. Which concept best captures the minority's likely complaint? A. Unfair prejudice or oppressive conduct. B. Automatic dissolution by frustration. C. Mandatory share forfeiture. D. Conversion of debt into equity. The correct answer is A. Unfair prejudice or oppressive conduct. Let us examine how majority power is being misused. Unfair prejudice or oppressive conduct arises when those controlling a company use their power in a manner that unfairly harms minority shareholders. Here, the controlling shareholder directs excessive fees to related entities and deprives the minority of a fair benefit from the company. Option B is incorrect because frustration concerns contractual obligations and does not automatically dissolve a company. Option C is incorrect because share forfeiture usually relates to a shareholder's failure to meet payment obligations on shares. Option D is also incorrect because converting debt into equity is a financing arrangement rather than a remedy for abuse of majority control. Question 16. Which statement best describes class rights attached to shares? A. Rights that apply only to directors' employment contracts. B. Rights that arise only when a company becomes insolvent. C. Rights attached to a particular category of shares. D. Rights that prevent all future share transfers. The correct answer is C. Rights attached to a particular category of shares. Let us distinguish class rights from other corporate rights. Class rights are legal or financial rights attached to a specific category of shares. These may include voting rights, dividend entitlements, redemption terms, or priority when capital is returned. Option A is incorrect because directors' employment terms arise from service contracts rather than share classifications. Option B is incorrect because class rights may operate throughout the company's existence, not only during insolvency. Option D is also incorrect because class rights do not automatically prohibit every future transfer of shares. Question 17. Which concept describes the minimum level of member presence required for a valid company meeting to proceed? A. Preemption. B. Novation. C. Ratification. D. Quorum. The correct answer is D. Quorum. Let us define the meeting requirement clearly. A quorum is the minimum number or proportion of members who must be present before a company meeting can validly conduct business. Presence may be physical or through another form of representation permitted by the company's rules or applicable law. Option A is incorrect because preemption gives existing shareholders priority when certain new shares are issued. Option B is incorrect because novation replaces an existing contractual obligation or party with a new one by agreement. Option C is also incorrect because ratification is the later approval of an act that was initially unauthorized. Question 18. A company grants a lender security over changing inventory and receivables while continuing to sell inventory in the ordinary course of business. Which form of security best fits this arrangement? A. Fixed charge over land only. B. Floating charge over circulating assets. C. Pledge of fully paid shares. D. Statutory lien over salaries. The correct answer is B. Floating charge over circulating assets. Let us examine why this form of security applies. A floating charge is designed to cover a changing pool of business assets, such as inventory and receivables. The company may continue using or disposing of those assets in the ordinary course of business until the charge crystallizes or enforcement begins. Option A is incorrect because a fixed charge usually attaches to a specific asset and does not suit constantly changing inventory. Option C is incorrect because a share pledge concerns shares rather than circulating business assets. Option D is also incorrect because a statutory lien over salaries does not describe security granted over inventory and receivables. Question 19. A board approves a risky expansion after reviewing market reports, financial forecasts, and expert advice. The project fails because of an unexpected market collapse. Which principle is most likely to protect the directors? A. Business judgment deference. B. Automatic shareholder ratification. C. Strict liability for poor outcomes. D. Personal ownership of company losses. The correct answer is A. Business judgment deference. Let us examine why the directors may be protected. Business judgment deference generally protects directors when they make informed decisions in good faith and for a proper purpose. Here, the board reviewed market reports, financial forecasts, and expert advice before approving the expansion. Therefore, the unexpected failure of the project does not automatically establish a breach of duty. Option B is incorrect because shareholder ratification is not automatic and may require proper approval. Option C is incorrect because directors are not usually strictly liable merely because a commercial decision produces a poor outcome. Option D is also incorrect because company losses belong to the company and do not automatically become the director's personal losses. Question 20. Which condition is generally necessary before a company may lawfully pay a dividend? A. The company must have no secured creditors. B. The directors must own ordinary shares. C. The dividend must be paid from available profits. D. The company must issue new shares first. The correct answer is C. The dividend must be paid from available profits. Let us examine the legal requirement for distributions. A company may generally pay a dividend only from profits or reserves legally available for distribution. This restriction supports capital maintenance and helps preserve company assets for creditors. Option A is incorrect because the existence of secured creditors does not automatically prevent a lawful dividend. Option B is incorrect because directors do not need to own ordinary shares before approving a dividend. Option D is also incorrect because a company is not required to issue new shares before distributing available profits. Question 21. A company proposes issuing a large block of new voting shares to an outside investor. Existing shareholders argue that their voting influence will be diluted unless they are offered shares first. Which right are they invoking? A. Redemption right. B. Inspection right. C. Liquidation preference. D. The correct answer is D. Preemption right. Let us connect the concern to the relevant shareholder protection. A preemption right gives existing shareholders priority to subscribe for certain newly issued shares before those shares are offered to outside investors. This helps shareholders preserve their proportionate ownership and voting influence. Option A is incorrect because a redemption right concerns the repayment or cancellation of redeemable shares. Option B is incorrect because an inspection right concerns access to specified company records. Option C is also incorrect because a liquidation preference determines priority when company assets are distributed during liquidation. Question 22. Which duty requires directors to act honestly for the benefit of the company rather than for an improper personal purpose? A. Duty to register charges. B. Duty of loyalty or good faith. C. Duty to maintain quorum. D. Duty to issue debentures. The correct answer is B. Duty of loyalty or good faith. Now let us focus on the director's core obligation. The duty of loyalty or good faith requires directors to act honestly in the company's interests and to exercise their powers for proper purposes. A director must not use the position to obtain an improper personal benefit at the company's expense. Option A is incorrect because registering charges concerns formal compliance for secured interests rather than honest decision-making. Option C is incorrect because quorum relates to the minimum attendance needed for a valid meeting. Option D is also incorrect because directors have no general duty to issue debentures. Question 23. Evaluate each statement as true or false. A derivative action is normally brought to remedy a wrong done to the company. The correct answer is true. A personal shareholder claim is always the correct remedy for misappropriation of company assets. The correct answer is false. Minority shareholders can freely override valid majority decisions merely because they disagree. The correct answer is false. Oppression remedies may address abusive conduct by those controlling the company. The correct answer is true. Let us distinguish the available shareholder remedies. A derivative action addresses harm suffered directly by the company, so the first statement is true. Misappropriation of company assets normally causes loss to the company itself, meaning a personal shareholder claim is not always the appropriate remedy, so the second statement is false. Minority shareholders cannot overturn a valid majority decision simply because they disagree with it, making the third statement false. However, where those in control act unfairly or abuse their power, oppression remedies may protect affected members, so the fourth statement is true. A company passes a major constitutional amendment at a meeting where notice was sent late to several members. The excluded members would have had enough votes to affect the result. What issue is most significant? A. Whether the company had a registered office. B. Whether directors owned enough shares. C. Whether meeting procedure and notice were valid. D. Whether employees approved the amendment. The correct answer is C. Whether meeting procedure and notice were valid? Let us examine the procedural problem. A major constitutional amendment must normally be approved through a properly conducted company meeting. This requires compliance with applicable notice periods, quorum rules, voting thresholds, and other procedural requirements. Here, several members received late notice, and their votes could have affected the outcome. So the validity of the resolution may be challenged. Option A is incorrect because having a registered office does not cure defective meeting procedures. Option B is incorrect because directors' share ownership does not determine whether members received proper notice. Option D is also incorrect because employees generally do not approve constitutional amendments unless they are also entitled to vote as members. Question 25. A company enters insolvent liquidation. The liquidator identifies secured creditors, employee claims, unsecured trade creditors, and shareholders. Which group is generally last to receive any residual value? A. Shareholders. B. Secured creditors. C. Preferential creditors. D. Unsecured creditors. The correct answer is A. Shareholders. Let us examine the order of financial claims. Shareholders are residual claimants, meaning they generally receive value only after the company's creditor claims and liquidation expenses have been satisfied. Secured creditors usually have priority through their security interests, so option B is incorrect. Preferential creditors, which may include certain employee claims, receive statutory priority over ordinary unsecured debts, making option C incorrect. Unsecured creditors rank below secured and preferential creditors, but still rank ahead of shareholders, so option D is also incorrect. Therefore, shareholders are generally the last group entitled to any remaining value. Question 26. Which remedy is most closely associated with a shareholder suing to enforce a right personally held as a member? A. Derivative action. B. Insolvency set-off. C. Personal action. D. Floating charge enforcement. The correct answer is C. Personal action. Let us distinguish a personal claim from other remedies. A personal action is used when a shareholder seeks to enforce a right owed directly to that shareholder. Examples include voting rights, rights under the company's constitution, or entitlement to proper meeting procedures. Option A is incorrect because a derivative action addresses a wrong suffered by the company rather than a personal shareholder right. Option B is incorrect because insolvency set-off concerns mutual debts between parties during insolvency. Option D is also incorrect because floating charge enforcement is a creditor remedy involving secured company assets. Question 27. A parent company owns all shares in a subsidiary. The subsidiary negotiates contracts in its own name, maintains separate accounts, and has its own board. A creditor sues the parent for the subsidiary's debt solely because ownership is complete. What is the strongest defense? A. The subsidiary has separate legal personality. B. The parent receives consolidated accounts. C. The creditor dealt with the group brand. D. The subsidiary is commercially dependent. The correct answer is A. The subsidiary has separate legal personality. Let us apply the principle to the corporate group. A subsidiary normally remains a separate legal person even when its parent company owns all its shares. Because the subsidiary contracts in its own name, keeps separate accounts, and has its own board, its debts generally remain its own obligations. Option B is incorrect because consolidated financial reporting does not merge the legal identities of the parent and subsidiary. Option C is incorrect because using a group brand alone does not automatically make the parent liable for the subsidiary's contracts. Option D is also incorrect because commercial dependence does not by itself remove separate legal personality. Question 28. Which objective is central to modern corporate governance? A. Eliminating all commercial risk from board decisions. B. Replacing directors with external auditors. C. Balancing authority, accountability, and oversight. D. Guaranteeing equal dividends every year. The correct answer is C. Balancing authority, accountability, and oversight. Let us examine the purpose of corporate governance. Corporate governance establishes structures for allocating decision-making power, supervising management, and holding company leaders accountable. It also promotes responsible conduct, transparency, and effective oversight. Option A is incorrect because commercial risk cannot be eliminated entirely from business decisions. Option B is incorrect because auditors provide independent assurance rather than replacing directors in managing the company. Option D is also incorrect because dividends depend on available profits, legal requirements, and valid corporate decisions, so equal annual payments cannot be guaranteed. Question 29. An audit firm provides extensive management consultancy services to a company while also auditing its financial statements. Shareholders question whether the auditor can objectively assess management's judgments. Which principle is most directly concerned? A. Auditor independence. B. Share transferability. C. Capital redemption. D. Proxy solicitation. The correct answer is A. Auditor independence. Let us examine why objectivity matters in an audit. Auditor independence requires the audit firm to remain free from relationships or interests that could impair its professional judgment. Providing extensive management consultancy services may create a self-review threat because the auditor could be required to evaluate decisions or systems it helped develop. Option B is incorrect because share transferability concerns the ability of shareholders to transfer their shares. Option C is incorrect because capital redemption concerns the repayment or cancellation of redeemable shares. Option D is also incorrect because proxy solicitation involves seeking authorization to vote on behalf of shareholders. Question 30. What does allotment of shares generally mean? A. Cancellation of shares after liquidation begins. B. Transfer of existing shares between members. C. Conversion of shares into secured debt. D. Creation and issue of shares to an applicant. The correct answer is D. Creation and issue of shares to an applicant. Let us distinguish allotment from other share transactions. Allotment occurs when a company assigns newly issued shares to an applicant, creating the applicant's entitlement to those shares. Option A is incorrect because canceling shares during liquidation is not an allotment. Option B is incorrect because transferring existing shares changes ownership between parties without creating new shares. Option C is also incorrect because converting shares into debt changes the form of financing rather than issuing shares to an applicant. Question 31. A company is nearing insolvency. Directors continue trading, take large deposits from customers, and know there is no realistic prospect of fulfilling the contracts. Which duty shift is most relevant? A. Greater attention to creditor interests. B. Higher priority for ordinary dividends. C. Automatic approval by shareholders. D. Immediate transfer of company property. The correct answer is A. Greater attention to creditor interests? Let us examine how approaching insolvency affects directors' duties. As a company approaches insolvency, directors may need to give greater consideration to the interests of creditors because creditors bear an increasing risk of financial loss. Continuing to accept large customer deposits while knowing the company cannot realistically fulfill the contracts may worsen those losses and expose the directors to liability. Option B is incorrect because paying ordinary dividends becomes less appropriate when the company lacks sufficient financial resources. Option C is incorrect because shareholder approval does not automatically excuse conduct that harms creditors. Option D is also incorrect because approaching insolvency does not automatically require an immediate transfer of all company property. Question 32. A company enters a transaction outside the stated objects in its constitution. The counterparty acted in good faith and had no reason to suspect internal limits. Which modern approach is most likely? A. The transaction is void in all cases. B. The transaction may bind the company externally. C. The counterparty becomes a member automatically. D. The directors lose all voting rights permanently. The correct answer is B. The transaction may bind the company externally. Let us examine how external parties are protected. Modern company law often protects a counterparty who enters a transaction in good faith without knowledge of internal constitutional restrictions. Therefore, the company may remain bound externally, even if its directors exceeded limits contained in the Constitution. Option A is incorrect because exceeding the company's stated objects does not automatically make every transaction void. Option C is incorrect because entering a contract with a company does not make the counterparty a member or shareholder. Option D is also incorrect because directors do not permanently lose their voting rights merely because an internal limit was exceeded. Question 33. What is a share premium account generally associated with? A. Amounts received above the nominal value of issued shares. B. Dividends paid to preference shareholders only. C. Profits earned from ordinary trading activities. D. Debts owed by shareholders to external creditors. The correct answer is A. Amounts received above the nominal value of issued shares. Let us distinguish share premium from ordinary company income. A share premium account records the amount a company receives when it issues shares for more than their nominal or par value. For example, if a share with a nominal value of $1 is issued for $5, the additional $4 is generally credited to the share premium account. Option B is incorrect because preference dividends are distributions to shareholders rather than share premium. Option C is incorrect because profits from trading activities are recorded as business income or retained earnings. Option D is also incorrect because debts owed to external creditors do not form part of the share premium account. Question 34. Evaluate each statement as true or false. A floating charge always prevents the company from selling charged inventory. The correct answer is false. A fixed charge usually allows unrestricted disposal of the secured asset. The correct answer is false. Registration of security interests can protect creditor priority and provide public notice. The correct answer is true. Crystallization can convert a floating charge into a fixed security interest. The correct answer is true. Let us clarify how these security interests operate. A floating charge generally allows a company to sell or replace circulating assets, such as inventory, during ordinary business operations before crystallization, so the first statement is false. A fixed charge usually restricts the company from disposing of the secured asset without the lender's consent, making the second statement false. Registering a security interest can provide public notice and help determine priority among competing creditors, so the third statement is true. Crystallization causes a floating charge to attach to specific assets and operate more like a fixed security interest, making the fourth statement true. Question 35. A lender insists that a company must not create later security over the same assets without consent. The company later grants another lender competing security. Which contractual device is most relevant to the first lender's concern? A. Share split clause. B. Proxy voting clause. C. Dividend waiver clause. D. Negative pledge clause. The correct answer is D. Negative pledge clause. Let us examine how this clause protects the lender. A negative pledge clause restricts a borrower from granting additional security over specified assets without the existing lender's consent. Its purpose is to prevent later security interests from weakening the first lender's position or priority. Option A is incorrect because a share split clause concerns changes to the number and nominal value of shares. Option B is incorrect because a proxy voting clause concerns authorization to vote on another person's behalf. Option C is also incorrect because a dividend waiver clause concerns a shareholder giving up entitlement to a dividend. Question 36. Which ground most commonly supports winding up a company on insolvency grounds? A. The company changed its registered office? B. The company cannot pay its debts as they fall due? C. The company appointed a new managing director? D. The company transferred shares between members? The correct answer is B. The company cannot pay its debts as they fall due. Let us identify the key indicator of insolvency. A company's inability to pay its debts when they become due is a common ground for insolvency-related winding up. This indicates that the company lacks sufficient liquidity to meet its financial obligations. Option A is incorrect because changing a registered office is an administrative decision and does not establish insolvency. Option C is incorrect because appointing a new managing director does not prove that the company cannot pay its debts. Option D is also incorrect because transferring shares between members concerns company ownership rather than the company's ability to meet its liabilities. Question 37. A person buys shares, but the company refuses to update the register of members without a valid reason. The buyer cannot vote or receive notices as a member. Which issue is most central? A. Failure to declare a final dividend. B. Failure to issue a floating charge. C. Failure to register the share transfer. D. Failure to appoint a liquidator. The correct answer is C. Failure to register the share transfer. Let us examine why registration is essential. A valid share transfer generally must be entered in the company's register of members before the buyer can fully exercise membership rights. Without registration, the buyer may be unable to vote, receive meeting notices, or be formally recognized as a member. Option A is incorrect because declaring a final dividend does not determine whether the buyer is entered in the register. Option B is incorrect because a floating charge concerns security over changing company assets rather than ownership of shares. Option D is also incorrect because appointing a liquidator relates to winding up the company and has no connection to registering a share transfer. Question 38. Which statement best distinguishes a fixed charge from a floating charge? A. A fixed charge usually attaches to specific assets. A floating charge covers changing assets. B. A fixed charge applies only to shares. A floating charge applies only to buildings. C. A fixed charge belongs to shareholders. A floating charge belongs to directors. D. A fixed charge ends at incorporation. A floating charge begins at liquidation. The correct answer is A. A fixed charge usually attaches to specific assets. A floating charge covers changing assets. Let us compare how each form of security operates. A fixed charge normally attaches to a specific identifiable asset, such as land, machinery, or equipment. The company usually cannot dispose of that asset freely without the lender's consent. A floating charge, however, generally covers a changing pool of assets, such as inventory or receivables, and allows ordinary business dealings until crystallization. Option B is incorrect because either type of charge may apply to different asset categories depending on the arrangement. Option C is incorrect because charges are security interests held by creditors, not rights belonging automatically to shareholders or directors. Option D is also incorrect because both fixed and floating charges may exist during the company's operations and are not defined by incorporation or liquidation dates. Question 39. A merger is approved by the required majority, but dissenting minority shareholders argue that the transaction undervalues their shares and forces them out unfairly. Which protection is most relevant? A. Automatic director immunity. B. Appraisal or fair value remedy. C. Compulsory audit rotation. D. Unlimited liability conversion. The correct answer is B. Appraisal or fair value remedy. Let us examine the protection available to dissenting shareholders. An appraisal or fair value remedy may allow dissenting shareholders to require payment of a judicially or independently determined fair value for their shares. This protection is particularly relevant when a major transaction, such as a merger, compels shareholders to give up their interests at an allegedly unfair price. Option A is incorrect because directors do not receive automatic immunity merely because the required majority approved the merger. Option C is incorrect because audit rotation concerns auditor independence rather than compensation for undervalued shares. Option D is also incorrect because converting the company to unlimited liability does not provide a fair value remedy to dissenting shareholders. Question 40. A director learns during board negotiations that the company plans to acquire a valuable software license. Before the company acts, the director buys the license personally and resells it at a profit. Which breach is most likely? A. Breach of quorum requirements. B. Breach of share transfer rules. C. Breach of dividend restrictions. D. Breach of corporate opportunity rules. The correct answer is D. Breach of corporate opportunity rules. Let us examine why the director's conduct creates a conflict. Corporate opportunity rules prevent directors from taking for themselves business opportunities that properly belong to the company. Here, the director learned about the license through board negotiations and acquired it personally before the company could act. The personal profit therefore arose from an opportunity connected to the director's position. Option A is incorrect because quorum requirements concern the minimum attendance needed for a valid meeting. Option B is incorrect because share transfer rules regulate changes in ownership of shares. Option C is also incorrect because dividend restrictions concern lawful distributions of company profits. Question 41. Which term best describes a person who is not formally appointed as a director, but whose instructions the board is accustomed to follow? A. Promoter. B. Auditor. C. Shadow director. D. Preference shareholder. The correct answer is C. Shadow director. Let us identify how this role arises. A shadow director is a person who has not been formally appointed to the board, but whose instructions or directions the directors are accustomed to follow. Such a person may be subject to certain duties and liabilities that apply to formally appointed directors. Option A is incorrect because a promoter helps establish or organize a company before incorporation. Option B is incorrect because an auditor independently examines the company's financial statements rather than directing the board. Option D is also incorrect because a preference shareholder holds a class of shares with specified priority rights but does not become a shadow director merely through share ownership. Question 42. Which principle allows a company to be bound by acts of an agent who appears to have authority because of the company's representation? A. Apparent authority. B. Capital reduction. C. Statutory merger. D. Share forfeiture. The correct answer is A. Apparent authority. Let us examine how this principle protects third parties. Apparent authority arises when a company's words or conduct reasonably indicate that an agent has authority to act on its behalf. A third party who relies in good faith on that representation may therefore enforce the agent's act against the company. Option B is incorrect because capital reduction concerns the lawful decrease of a company's share capital. Option C is incorrect because a statutory merger combines companies through a legally prescribed process. Option D is also incorrect because share forfeiture generally concerns the cancellation of shares when a shareholder fails to meet required payment obligations. Question 43. A venture capital investor appoints a nominee director to the board. The investor demands that the nominee vote only to protect the investor's interests, even when the proposal may harm the company. What should the nominee director do? A. Follow the appointing shareholder in all cases. B. Abstain from every vote involving finance. C. Transfer voting power to the auditor. D. Act in accordance with duties owed to the company. The correct answer is D. Act in accordance with duties owed to the company. Let us examine the nominee director's legal position. A nominee director may consider the interests of the shareholder who appointed them, but their primary legal duties are still owed to the company. Therefore, the director must exercise independent judgment and should not support a proposal that harms the company merely to benefit the appointing investor. Option A is incorrect because a nominee director cannot blindly follow the shareholder's instructions in every situation. Option B is incorrect because the director is not required to avoid every financial decision and should instead assess each matter properly. Option C is also incorrect because an auditor does not take over a director's voting powers or management responsibilities. Question 44. Which concept best explains why majority rule is limited in company law? A. Majority shareholders must never control ordinary decisions. B. Minority members may require protection from abusive control. C. Directors must approve all shareholder voting decisions. D. Creditors become members whenever dividends are unpaid. The correct answer is B. Minority members may require protection from abusive control. Let us examine the balance between control and protection. Majority rule allows shareholders holding sufficient voting power to make ordinary company decisions. However, that power is not unlimited because minority members may need protection from fraud, oppression, unfair prejudice, or other abuses of control. Option A is incorrect because majority shareholders may legitimately control many ordinary decisions through valid voting procedures. Option C is incorrect because directors do not generally approve every decision made by shareholders. Option D is also incorrect because unpaid dividends do not convert creditors into company members. Question 45. Evaluate each statement as true or false. A company's constitution may allocate powers between directors and shareholders. The correct answer is true. Special resolutions are often required for significant constitutional changes. The correct answer is true. Shareholders usually manage day-to-day business directly in large companies. The correct answer is false. Directors may ignore the Constitution whenever commercial urgency exists. The correct answer is false. Let us examine how internal corporate authority is structured. A company's constitution commonly distributes powers between directors and shareholders, so the first statement is true. Significant constitutional amendments often require approval through a special resolution, making the second statement true. In large companies, directors generally manage daily business under delegated authority, while shareholders exercise voting rights on specified matters, so the third statement is false. Commercial urgency does not normally permit directors to disregard constitutional restrictions or procedural requirements, making the fourth statement false. Question 46. A company alters its articles to allow compulsory acquisition of minority shares at a price far below fair value, mainly to remove a dissenting investor. Which challenge is most likely? A. The alteration was not made for a proper corporate purpose. B. The company failed to create a floating charge. C. The auditor approved the alteration too early. D. The shares were listed on a securities exchange. The correct answer is A. The alteration was not made for a proper corporate purpose. Let us examine the limits on majority power. A company may alter its articles through the required approval process, but the alteration must generally serve a proper corporate purpose and must not unfairly abuse minority shareholders. Here, the compulsory acquisition provision is designed mainly to remove a dissenting investor at a price far below fair value, which may indicate oppressive or improper use of majority power. Option B is incorrect because a floating charge concerns security over changing company assets and has no connection to the validity of the alteration. Option C is incorrect because auditor approval is not the central requirement for amending the articles. Option D is also incorrect because listing the shares on a securities exchange does not determine whether the alteration was made for a proper purpose. Question 47. A company issues preference shares that receive dividends before ordinary shares but carry no vote except on class matters. A later amendment removes the dividend priority without class consent. Which issue arises? A. Improper liquidation of ordinary shares. B. Invalid appointment of a proxy holder. C. Variation of class rights. D. Failure of separate personality. The correct answer is C. Variation of class rights. Let us examine why class approval may be required. The priority to receive dividends is a right attached specifically to the preference share class. Removing that priority changes the legal and financial rights of those shareholders and therefore amounts to a variation of class rights. Such a variation may require approval from the affected class under the company's constitution or applicable law. Option A is incorrect because no liquidation of ordinary shares has occurred. Option B is incorrect because the issue does not concern the authority or appointment of a proxy holder. Option D is also incorrect because the company continues to have a legal identity separate from its shareholders. Question 48. What is the primary governance purpose of an audit committee? A. To replace the board in setting commercial strategy. B. To guarantee that the company earns annual profits. C. To approve all employment contracts below board level. D. To oversee financial reporting, controls, and audit integrity. The correct answer is D. To oversee financial reporting, controls, and audit integrity. Let us examine the committee's oversight role. An audit committee supports the board by overseeing the reliability of financial reporting, the effectiveness of internal controls, the external audit process, and related risk matters. Option A is incorrect because the audit committee does not replace the board in setting the company's commercial strategy. Option B is incorrect because no committee can guarantee that a company will earn profits every year. Option C is also incorrect because approving routine employment contracts is generally a management or human resources responsibility rather than the audit committee's primary function. Question 49. A company agrees to fund a buyer's purchase of its own shares using company assets, leaving the company weaker after the transaction. Which doctrine or rule area is most relevant? A. Corporate financial assistance. B. Director qualification shares. C. Proxy appointment procedure. D. Register of debenture holders. The correct answer is A. Corporate financial assistance. Let us examine why this transaction raises concern. Corporate financial assistance rules regulate situations where a company uses its own assets to help another person acquire shares in that company. These rules are intended to protect company capital and creditors from transactions that weaken the company for the benefit of a share purchaser. Option B is incorrect because director qualification shares concerns shareholding requirements for directors rather than funding a share acquisition. Option C is incorrect because proxy appointment procedures concern authorizing another person to vote at a meeting. Option D is also incorrect because a register of debenture holders records creditors holding debentures and does not regulate assistance for purchasing company shares. Question 50. What is corporate capacity? A. The legal ability of a company to enter transactions and hold rights. B. The market value of all shares traded during the year. C. The number of directors required to form a quorum. D. The accounting reserve created after a profitable quarter. The correct answer is A. The legal ability of a company to enter transactions and hold rights. Let us define this concept clearly. Corporate capacity refers to a company's legal ability to perform acts in its own name. This includes entering contracts, owning property, acquiring rights, and assuming legal obligations. Option B is incorrect because the market value of traded shares concerns share pricing rather than legal capacity. Option C is incorrect because a quorum is the minimum number of directors or members required for a valid meeting. Option D is also incorrect because an accounting reserve relates to the company's financial records rather than its legal power to act. Question 51. A regulator requires disclosure of individuals who ultimately control a company through layered entities. The company lists only the immediate corporate shareholder and refuses further disclosure. Which policy objective is most implicated? A. Protection of fixed charge holders only. B. Restriction of ordinary share transfers. C. Transparency of beneficial ownership. D. Automatic conversion of debt to shares. The correct answer is C. Transparency of beneficial ownership. Let us examine the purpose of this disclosure requirement. Beneficial ownership transparency aims to identify the natural persons who ultimately own, control, or benefit from a company, even when their interests are held through several corporate entities. Listing only the immediate corporate shareholder may conceal the individuals exercising ultimate control. Option A is incorrect because beneficial ownership disclosure is not limited to protecting fixed charge holders. Option B is incorrect because the rules do not primarily restrict transfers of ordinary shares. Option D is also incorrect because beneficial ownership disclosure has no connection to converting company debt into shares. Question 52. Two equal shareholders in a private company are also its only directors. They disagree permanently on finance, hiring, and strategy, causing paralysis of board and member decisions. Which remedy is most relevant? A. Routine annual return filing. B. Automatic share premium transfer. C. Unconditional dividend declaration. D. Deadlock remedy or winding up relief. The correct answer is D. Deadlock remedy or winding up relief. Let us examine how the law may address corporate paralysis. A persistent deadlock can prevent a closely held company from making essential board and shareholder decisions. In such circumstances, a court may consider remedies such as a compulsory buyout, other deadlock relief, or winding up where continued operation is no longer practical. Option A is incorrect because filing an annual return does not resolve disagreement between equal owners. Option B is incorrect because transferring share premium does not restore decision-making authority. Option C is also incorrect because declaring a dividend without proper financial and corporate approval would not solve the underlying deadlock. Question 53. Which record is most closely connected with identifying the legal members of a company? A. Customer Complaints Register. B. Register of Members. C. Marketing Distribution List. D. Supplier Quotation File. The correct answer is B. Register of Members. Let us identify the record that establishes formal membership. The Register of Members records the individuals or entities recognized as legal members of the company. It commonly includes details such as member names, shareholdings, and the dates on which membership began or ended. Option A is incorrect because a customer complaints register records service issues rather than ownership rights. Option C is incorrect because a marketing distribution list contains promotional contacts and does not prove company membership. Option D is also incorrect because a supplier quotation file relates to proposed purchases rather than shareholder status. Question 54. A private company plans to offer shares widely to public investors and list them for trading. Which legal concern becomes most significant? A. Compliance with public offering and disclosure rules. B. Removal of all directors before issuing shares. C. Automatic cancellation of existing member rights. D. Conversion of every debt into ordinary shares. The correct answer is A. Compliance with public offering and disclosure rules. Let us examine why public fundraising requires greater regulation. Offering shares widely to public investors and listing them for trading generally triggers stricter legal requirements concerning disclosure, governance, and investor protection. The company may need to provide accurate financial and business information so that investors can make informed decisions. Option B is incorrect because directors do not need to be removed before a company can issue shares to the public. Option C is incorrect because a public offering does not automatically cancel the rights of existing members. Option D is also incorrect because company debts are not automatically converted into ordinary shares when the company seeks a public listing. Question 55. Which statement best describes voluntary liquidation? A. A creditor forcibly seizes company assets without process. B. Members or the company initiate winding up through prescribed procedures. C. Directors secretly transfer assets to avoid creditor claims. D. Auditors replace shareholders and continue trading indefinitely. The correct answer is B. Members or the company initiate winding up through prescribed procedures. Let us examine how voluntary liquidation begins. Voluntary liquidation occurs when the company or its members initiate a formal process to end the company's operations, settle its liabilities, and distribute any remaining assets lawfully. Option A is incorrect because a creditor cannot simply seize company assets without following the required legal enforcement process. Option C is incorrect because secretly transferring assets to defeat creditor claims may amount to unlawful or fraudulent conduct rather than liquidation. Option D is also incorrect because auditors do not replace shareholders or continue operating the company indefinitely during liquidation. Question 56. A company holds a fully virtual general meeting. Several members are excluded because the platform fails while votes are taken on major resolutions. Which governance issue is most important? A. Whether the meeting technology was expensive. B. Whether the directors preferred online voting. C. Whether auditors attended the meeting remotely. D. Whether members had effective participation rights. The correct answer is D. Whether members had effective participation rights. Let us examine the procedural fairness required. A virtual general meeting must still give eligible members a genuine opportunity to access the meeting, participate in discussions, and cast their votes. Because several members were excluded by the platform failure while major resolutions were decided, The validity and fairness of the meeting process may be challenged. Option A is incorrect because the cost of the technology does not determine whether the meeting was valid. Option B is incorrect because the director's preference for online voting does not override members' participation rights. Option C is also incorrect because remote auditor attendance is not the central issue when members were unable to participate effectively. Question 57. Which description best defines a company promoter? A. A person involved in forming a company and arranging its initial structure. B. A person appointed only to audit annual financial statements. C. A creditor who enforces security after insolvency begins. D. A shareholder who receives dividends before directors meet. The correct answer is A. A person involved in forming a company and arranging its initial structure. Let us define the promoter's role clearly. A company promoter is a person who takes part in establishing a company and organizing its initial business structure. This may include arranging capital, preparing formation documents, identifying directors, and negotiating preliminary contracts. Option B is incorrect because auditing annual financial statements is the responsibility of an auditor rather than a promoter. Option C is incorrect because enforcing security during insolvency is a creditor function and does not involve forming the company. Option D is also incorrect because receiving priority dividends may relate to preference shares rather than the role of a promoter. Question 58. A company proposes returning part of its paid-up capital to shareholders because it has excess capital. Creditors object that the transaction may weaken the asset base available to satisfy debts. Which legal area governs this concern? A. Proxy voting procedure. B. Director appointment rotation. C. Beneficial ownership reporting. D. Capital reduction safeguards. The correct answer is D. Capital reduction safeguards. Let us examine how company capital is protected. Capital reduction safeguards regulate the circumstances in which a company may lawfully return paid-up capital to shareholders or otherwise reduce its capital base. These safeguards commonly require prescribed approvals and measures to protect creditors whose claims may be affected. Option A is incorrect because proxy voting concerns authorization to vote on behalf of a member. Option B is incorrect because director appointment rotation concerns board composition and tenure. Option C is also incorrect because beneficial ownership reporting identifies the individuals who ultimately own or control the company. Question 59. Which concept most directly concerns board actions designed to resist an unwanted takeover bid? A. Share premium accounting. B. Registered office maintenance. C. Takeover defense regulation. D. Annual return certification. The correct answer is C. Takeover defense regulation. Let us examine the limits on defensive board action. Takeover defense regulation governs measures adopted by directors to resist or frustrate an unwanted takeover bid. These rules consider whether the board is protecting legitimate company interests or improperly preventing shareholders from deciding whether to accept the offer. Option A is incorrect because share premium accounting concerns amounts received above the nominal value of issued shares. Option B is incorrect because registered office maintenance concerns the company's official legal address. Option D is also incorrect because annual return certification concerns periodic corporate filing obligations rather than resistance to a takeover bid. Question 60. Which situation most strongly supports lifting the corporate veil under general company law principles? A. A company changes its board after a poor trading year. B. A shareholder receives dividends from lawful profits. C. A company is used as a facade to evade existing legal obligations. D. A director votes against a proposed ordinary resolution. The correct answer is C. A company is used as a facade to evade existing legal obligations. Let us examine when separate legal personality may be disregarded. A court may lift the corporate veil when a company is used as a facade to conceal wrongdoing or evade an existing legal obligation. In that situation, the court may look beyond the company's separate identity and examine the individuals controlling it. Option A is incorrect because changing the board after poor performance is a normal corporate action. Option B is incorrect because receiving dividends from lawfully available profits does not constitute misuse of the company structure. Option D is also incorrect because voting against an ordinary resolution is a legitimate exercise of a director's decision-making role.